Committee will come to order. The committee is meeting today to consider Senate S-375, Senator Mendez's bill to require greater disclosure by professionals involved in the Puerto Rico bankruptcy cases, and H.R. 1192, the House companion measure, which the House passed earlier this year. I'm pleased to welcome our dear friend, Senator Mendez, who has joined us this morning to provide a few remarks. And we also are very fortunate to have Judge Arthur Gonzalez with us. Early in his career, Judge Gonzalez served as a United States trustee, which for those of us not familiar with bankruptcy law is a Justice Department official who oversees the administration of bankruptcy cases. He served for 17 years as a bankruptcy judge in his Southern District of New York, and for the past 5 years, he has been a member of the Financial Oversight and Management Board for Puerto Rico. Judge Gonzalez has not only 30 years of experience with bankruptcy law, but also firsthand knowledge of the cases that are the focus of the bills before us. We are also fortunate to have Professor Stephen Lubin, who teaches bankruptcy law in Seton Hall and is a recognized authority on the subject. And I appreciate Anthony Suarez joining us today, who is an experienced trial attorney, former Florida state legislator, and former president of the Puerto Rico Bar Association of Florida. Professor Lubin and Mr. Suarez will both be testifying remotely, and we are pleased to have their testimony. I want to take a few minutes to review how we got here today, because this is a unique and complicated situation. I think it's important that we all start from the same place. 5 years ago, Congress passed a law known as Promisa to address Puerto Rico's financial crisis. Puerto Rico was over $70 billion in debt at the time and faced another $50 billion in unfunded pension liabilities. It could no longer pay its debts as they became due. But unlike a municipal government in one of the 50 states, Puerto Rico could not declare bankruptcy because our bankruptcy laws exclude Puerto Rico from Chapter 9, as the municipal bankruptcy provisions in the Bankruptcy Code are known. To address Puerto Rico's financial crisis, Promisa created the Financial Oversight Board, and it gave the board sweeping powers to help put Puerto Rico's financial affairs in order. It also created a new, unique bankruptcy-like procedure by which the Oversight Board could come up with plans to restructure Puerto Rico's debt, subject to the approval of a district court judge designated by Chief Justice Roberts. 4 years ago, the Oversight Board filed 6 of these bankruptcy-like cases to restructure the debts of the Commonwealth and 5 of its public authorities. Considerable progress has been made since then. The restructuring plan in one of these cases has already been confirmed by the court. The joint plan covering 3 cases is now awaiting approval by the court, and the 2 remaining cases could be completed next year. Which brings us to the legislation before us. Puerto Rico's bankruptcy cases, like any large corporate bankruptcy case or any municipal bankruptcy case, are complicated affairs. They require legions of lawyers and accountants and consultants and other professionals, all of whom expect to be paid for their work. In a corporate bankruptcy, the debtor cannot hire professional help without the bankruptcy court's approval, and the courts won't approve hiring professionals until they disclose any potential conflicts of interest. That is not the case with municipal bankruptcies. To protect state sovereignty, Chapter 9 lets municipal governments hire professionals without court approval and without requiring applicants to disclose potential conflicts before they are hired. As Puerto Rico is a sovereign territory, Promisa's bankruptcy provisions were modeled after the municipal bankruptcy provisions in Chapter 9. The bills before us would change that and require professionals retained to work on cases under Promisa to make the same sorts of disclosures that professionals must make in corporate bankruptcy cases. That strikes me as a sensible thing to do. I suspect we can all agree that professionals should disclose potential conflicts. That is likely why the House was able to pass the bill unanimously. I, too, support requiring more disclosure, but I'm concerned that the way the bill goes about, it may have adverse effects on the pending cases. I don't think I'm alone in having these concerns. Robert Keach, former president of the American Bankruptcy Institute, warned the House Judiciary Committee 2 years ago that enactment of the bill could be highly disruptive of the current proceedings and the considerable progress that has been made in the Promisa cases. Similarly, Natalie Jurisco, the Oversight Board's executive director, warned the House Natural Resources Committee last year that the bill was overly expansive and that requiring disclosure on the scale proposed would be an impossible exercise. These points were not addressed when the House passed this bill. It's my hope that this can be part of our discussion with our witnesses this morning, and that it will help us find a way to increase disclosure, guard against conflicts of interest, which I support, but in a way that is feasible and will not disrupt the pending cases. With that, let me turn to my ranking member Barrasso for his opening remarks.
Well, thank you very much, Mr. Chairman. Today we are here to receive testimony on the Puerto Rican Recovery Accuracy in Disclosure Act of 2021, or PRADA. This bill would require professionals hired in debt adjustment cases involving Puerto Rico to file disclosure statements outlining their connections with debtors, creditors, with the Puerto Rico Financial Management Oversight Board, and other interested parties. The bill would act retroactively for entities that have already completed their work and require those entities to file disclosure statements within 60 days. The Senate version of this bill has been introduced by Senators Menendez and Rubio. The House bill, introduced by Representative Velazquez, unanimously passed the House in February 24th of this year. Unanimously, Mr. Chairman. So first, I want to welcome the witnesses testifying before us, and particularly I want to welcome Mr. Anthony Suarez. He has a long and distinguished legal career. He was a member of the Florida State Legislature, a United States delegate to the Guatemala Peace Accords in 1996, and president of the Puerto Rican Bar Association of New York and of Florida. Currently has his own law practice and is also an adjunct professor of law at Barry University School of Law in Orlando, Florida. Mr. Suarez, thank you for agreeing to testify today. Mr. Chairman, Congress passed the Puerto Rico Oversight, Management, and Economic Stability Act in 2016. This was a direct result of worsening fiscal situation in Puerto Rico. I was a member of this committee at the time. The legislation established an oversight board to help manage Puerto Rico's fiscal matters as it relates to financial planning and the budget of the island. Under this law, the board has the power to hire professionals who could assist in these fiscal matters. Advisors to the Territory's Oversight Board were excluded from the disclosure requirements under Promisa. The Pravda bill will ensure that some form of financial disclosure is added to Promisa to address this, to ensure transparency for the public. Today, we will hear testimony as to the benefits and the need for this proposed legislation. In my home state of Wyoming, a U.S. territory until 1890, our legislature considers it a matter of responsibility to our taxpayers to keep our fiscal house in order. As a former member of the state legislature, I can speak to this fact. Residents in my state expect no less. Coal, oil, and natural gas producers provide needed state revenue, which funds vital public services such as schools, roadways, and public safety. Despite the administration's best efforts to end American oil, natural gas, and coal production, the Wyoming delegation in Congress continues to fight to protect these important industries so we can generate the revenue to keep our state's fiscal house in order. Each state and territory has their own unique fiscal challenges. However, there is one thing we can ensure, and that we may maintain transparency in our fiscal dealings. Fiscal disclosure requirements make sense. We have them here in the Senate. They should also apply to the financial dealings of advisors to Puerto Rico's Oversight Board hired under Promisa. So again, thank you to the witnesses. Thank you to Senator Menendez and Senator Rubio for introducing the bill. And thank you, Mr. Chairman.
Thank you, Senator Barrasso. And next, let me welcome our friend Senator Menendez for his remarks.
Thank you, Mr. Chairman, and Ranking Member Barrasso and distinguished members of the committee for holding this hearing on the Puerto Rico Recovery Accuracy and Disclosures Act of 2021, or PRADA. As the lead sponsor of PRADA, along with Senator Rubio, I appreciate the opportunity to speak to you today about what I believe is an urgent need to enact this bipartisan and bicameral legislation. I also want to thank my colleague, Congresswoman Velazquez, for her tireless advocacy for the people of Puerto Rico and her leadership on this issue, along with my colleagues, Senator Rubio, Hirono, Wicker, Blumenthal, Wyden, and Stabenow for their co-sponsorship. PRADA is a rather straightforward bill. It would simply close a loophole in existing law to ensure that advisors and consultants to Puerto Rico's Fiscal Oversight Board follow the same transparency and disclosure practices as would be required in other U.S. bankruptcy cases. As my colleagues will recall, in 2016, Congress passed the Puerto Rico Oversight, Management, and Economic Stability Act, or Promisa, which aimed to create a standardized bankruptcy process for Puerto Rico to allow the island to restructure its debts while meeting its obligations to creditors and maintaining services for the people of the island. Promesa created the Fiscal Oversight and Management Board, or La Junta as it's known on the island, which currently has sweeping authority over Puerto Rico's debt restructuring and budget. Unfortunately, Promesa did not require the Oversight Board's advisors and consultants to disclose conflicts of interest with creditors to whom Puerto Rico owes money. By failing to hold these advisors and consultants to the same transparency standards required on the mainland, Promesa created yet another unjust double standard for the people of Puerto Rico. I oppose Promesa because I believed it would not do enough to protect the people of Puerto Rico during the debt restructuring process. And while I like to be right as much as I can, this is one area where I wish I had been wrong. In many ways, the Oversight Board has made life on the island harder and less fair for so many Puerto Ricans. The legislation the committee is considering today would address one key issue created by Promesa. It would simply hold the cadre of vendors, consultants who have profited as a result of the law to reasonable transparency standards. Parada would require advisors and consultants working for the Oversight Board to disclose any potential conflicts of interest and to comply with the same robust transparency practices that are required for those providing advice to bankruptcy cases on the U.S. mainland. Puerto Rico has suffered natural disasters and economic devastation from Hurricanes Irma and Maria, and during the Trump administration, it is well documented that relief for Puerto Rico was improperly withheld, inadequate, and woefully insignificant. The American citizens who call the island home are enduring a debt restructuring process that is deeply unpopular because of the painful cuts that have been forced by the Oversight Board so that the island can pay its creditors. Think for a moment about the combined weight of these issues: natural disaster, economic devastation, inadequate relief when it needed it the most. So, colleagues, please understand in this context how extraordinarily unfair it is that we have a system whereby the people of Puerto Rico are footing the bill for these consultants who aren't even required to disclose their own conflicts of interest. The Weekly Journal recently reported that, quote, 4 years after Puerto Rico filed for bankruptcy under Title III of the federal Promesa law, over $830 million in attorney fees have been paid. $830 million. And yet, the island is far from putting an end to the more than $72 billion debt restructuring process. At a baseline, shouldn't we give the people of the island access to this basic level of transparency about the consultants and advisors providing input on the restructuring process, which would be done in any similar proceeding? Now, I know that bankruptcy law can be complicated, but transparency shouldn't. To me, it's shocking that you can be the referee and the coach. We have consultants who have clients as bondholders and yet advising the board at the same time. How do you play referee and coach and get paid for both of them? That's what we're trying to create a light on here. I know that there are interests involved, but it's the interest of the 3.5 million people of Puerto Rico that deserve to be upheld the most. This bill pursues fairness and equity for the people of Puerto Rico, and let me note that not even the member of the Promesa Board testifying today, even the member of the Promesa Board testifying today is supportive of the goals of our bill, and I appreciate that. Our colleagues in the House have passed this bill not once, but twice, and both times unanimously. I appreciate, Mr. Chairman and Ranking Member, for you to hold this hearing and give this matter attention. I also hope you will act swiftly to right this injustice. Thank you again for consideration of this vital legislation.
Thank you, Senator Menendez. We appreciate very much you being here. Now we're going to turn to our witnesses who I introduced a moment ago. We're very happy to have you all join us this morning and appreciate your expertise. We'll begin with Judge Gonzalez. Look at I think you might still be on, Judge. Look, just go ahead. That's the timer. That doesn't do anything. We're good.
Thank you.
Okay. Thank you, sir. Thank you for being here.
Thank you as well. Chairman Manson, Ranking Member Barrasso, members of the committee, my name is Arthur Jay Gonzalez. I am a member of the Promisa Board and a senior fellow at New York University School of Law, teaching courses in bankruptcy law. I became a senior fellow in March 2012 upon my retirement as Chief Judge of the United States Bankruptcy Court for the Southern District of New York. Prior to becoming a bankruptcy judge in 1995, I was United States trustee for Region 2, that includes the states of New York, Vermont, and Connecticut. During my early legal career as an attorney, I was a district counsel attorney at the Office of Chief Counsel of the Internal Revenue Service. Prior to graduating from law school and entering the practice of law, I spent 12 years as a teacher in the New York City public school system. Thank you for inviting me to testify today before the committee regarding the Puerto Rico Recovery, Accuracy, and Disclosure Act of 2021. My testimony regarding the bill will primarily draw from my experience with the interpretation and application of Bankruptcy Rule 2014 and the determination of disinterestedness under Section 101.14 of the Bankruptcy Code and the potential application and impact on the Promisa Title III cases pending in the United States District Court in Puerto Rico. Section 2A of the bill before this committee is premised in large part upon the disclosure requirements of Rule 2014. As a bankruptcy judge and U.S. trustee, I gained a great deal of experience regarding issues of disclosure and under Rule 2014 in the context of large, complex bankruptcy cases, often referred to as mega cases. During my career as a bankruptcy judge, I presided over a number of mega cases, including Enron, WorldCom, Chrysler, and Sunbeam. Further, during my career, I reviewed, either directly or indirectly, well over 1,000 professional persons retention applications. Such review included submissions of verified statements under Rule 2014, dealing with disclosures related to the retention process. My comments and observations regarding Pravda that I believe may aid in its implementation and furtherance of its goal are contained in my written statement submitted to this committee. For purposes of my oral testimony this morning, I would like to emphasize certain points of my written testimony. As an initial matter, I would like to state that as a Promisa board member, I fully support the board's purpose to extend the disclosure requirements of federal rules of bankruptcy procedure to professional persons seeking compensation under Promisa sections 316 and 317. This will help avoid conflicts of interest and provide greater transparency through enhanced disclosure. I believe it is essential to the effectiveness of the bill that certain sections of the bill be clarified or modified so it can be implemented without unnecessary litigation to ensure its purpose be accomplished. I would now turn to the points in my written testimony that I would like to emphasize. First, implementation of the bill should be consistent with the application of Rule 2014 as that rule is implemented in large bankruptcy cases. In that, an interested party list should be used to perform the Rule 2014 connections analysis. In that analysis, were it to be required to be done on the more than 165,000 creditors, it would be virtually impossible to complete in any relevant time frame and be extraordinarily costly. Further, for the on-island firms, the staffing requirement for such massive effort does not exist. An interested party process will ensure a timely and effective implementation of the bill. Further, an interested parties list analysis would yield the results necessary to achieve the goals and purpose of the bill. Second, the bill should be clarified to provide that any action regarding issues raised under the bill are brought before the Title III court presiding over the fees and expenses sought under Promisa sections 316 and 317. As I stated on my written testimony, that I believe if an issue under the bill were to be brought in another district court, such matter would be transferred to the Title III court, but nonetheless, I believe clarity as to this issue would avoid unnecessary litigation. Further, the board should be clarified as to whether a party in interest can raise an issue under the bill if the U.S. trustee has not filed an objection under Section 2B2. One aspect of this I did not put in my written testimony, and it came to my attention yesterday as I thought this through. The bill is not retroactive as to the fees incurred prior to the enactment of, incurred and ordered prior to the enactment of the bill. But it is retroactive with respect to the look back for purposes of connections. The issue I see with that could be problematic is that the interested party list that is developed now in 2021 would not necessarily be the same parties that existed in 2017. So when you look back, the list would be a mismatch. Second, the professionals in 2017, 18, 19, those firms may well have changed, their client base may have changed, so it would be difficult and awkward to apply it retroactively. I'm not sure it would lead any greater information, but nonetheless, I still think it would be difficult to do it. And I would ask the committee to consider that fact that it would be a cumbersome, expensive process to attempt to recreate what would have been an interested party list in the 4-year history of the case.
Thank you, Judge. We appreciate it.
Thank you.
Next, I'll recognize Professor Lubin for his statement.
Thank you, Senator Manchin, for inviting me to testify today. I appreciate the opportunity to play at least some small role in Puerto Rico's debt restructuring. As you noted, we're here today to talk about PRADA, but you can't really talk about PRADA without talking about Promisa because PRADA is basically a supplement to Promisa. And Promisa created a special bankruptcy proceeding, a unique bankruptcy proceeding that is unique to Puerto Rico and its municipal entities. And it's unique in other ways because it draws from both Chapter 11 and Chapter 9. As you noted in your opening remarks, in Chapter 11 corporate bankruptcy cases, the courts have a lot of oversight over professionals and their fees. The court approves retention of the professional, and the court also approves payment of the professionals. In Chapter 9, on the other hand, there's almost no court oversight at all. It's very, very slight. Now, arguably, and obviously that's subject of a different committee and a different hearing, arguably Chapter 9 should be updated in this regard. But I currently believe that current Chapter 9 is kind of a relic of the 1930s when Congress was attempting to develop a municipal bankruptcy system in the face of a fairly hostile Supreme Court. Promisa essentially splits the difference between Chapter 9 and Chapter 11. Retention is fully discretionary. There's no court oversight at all over retention of professionals, but payment of professionals is subject to court approval, and that's more like Chapter 11. In Chapter 11, when the court is considering whether or not to pay those professionals, it has in front of it, as has been noted, a wide array of disclosure information about the professionals that was triggered by the retention decision. And then the disclosure system then flows over to the payment issue because bankruptcy courts will then deny compensation to professionals that had undisclosed conflicts of interest. PRADA essentially establishes a comparable system, right, for the Puerto Rican bankruptcy system, and I think that makes a lot of sense. And I'm just going to sort of highlight 3 reasons why I think that makes a lot of sense. First of all, under Section 316 of Promisa, the court is supposed to award compensation where it is reasonable compensation. Well, it seems to me that not having a conflict of interest is sort of an inherent important factor in deciding whether or not the compensation is reasonable. So for that reason, it makes a lot of sense to enact PRADA. Secondly, as has been mentioned in passing a couple of times, ultimately it is the people of Puerto Rico who are paying the cost of all these professionals. Somebody who's paying the bill, I think, has a right to know this kind of information, whether or not a professional that is being paid is working under a conflict of interest. So that's the second reason why I think it makes a lot of sense to enact PRADA. And third and finally, as has also been mentioned in a couple of statements, the people of Puerto Rico are being asked to make serious sacrifices as part of the debt restructuring process. For example, many former employees of the Puerto Rican government are likely facing cuts to their pension payments. In that context, I think, again, people have a right to know that the debt restructuring process is being run in a transparent way with full disclosure as to whose interests are being promoted in the bankruptcy process. And indeed, I think this third reason is almost standing alone a reason to pass PRADA, because basically what I'm saying here is that transparency can help promote legitimacy of the process. And that is a reason alone to pass PRADA. So I thank you for allowing me to speak today, and I look forward to answering any questions you have about the bill as well.
Thank you, Professor. And next we'll have Mr. Suarez.
Thank you, Senator Manson, and all members of the committee for inviting me to give the opportunity to express my point of view on this issue of being down here in the trenches as we do. My name is Anthony Suarez, and I am president of the Suarez Law Group, but I'm also the president of the Legal Services Clinic of the Puerto Rican Community, a non-for-profit law firm that we started after Hurricane Maria. And I am, of course, an American citizen of Puerto Rican descent. My grandfather migrated to New York in 1920. However, I've always maintained a great interest in the island and my cultural heritage. In that capacity, as was indicated in the introduction, I gained election as president of the Puerto Rican Bar Association of New York in 1988, and then as president of the Puerto Rican Bar Association of Florida 30 years later. As far as I know, the only person who has even attempted that one. In 1999, I was elected to the Florida House of Representatives, and at that time was the only representative of Puerto Rican descent in the state of Florida, and I served alongside today's United States Senator Marco Rubio, who was just then entering the Florida House. Now, I've traveled extensively around the island and was invited, and have been invited as a speaker to the Colegio de Abogados of Puerto Rico, the Bar Association, to speak to their bar members, to speak to the Attorney General and members of the Puerto Rican Puerto Rican Supreme Court, affecting in reference to issues affecting the Puerto Rican diaspora, those of us who live on the mainland. And so the question here comes is about this bill. Well, it affects the reputation. The reputation of the Puerto Rican government over the years has been tarnished greatly. This affects not only Puerto Ricans on the island, but it affects all of us who cherish the island and our relationship with the United States body politic. Perception is everything. And in this process, it is not only urgent that you pass this bill, it is irreplaceable, absolutely necessary. This bill will be reported widely on the island and around the nation. It will enhance the concept the governmental process is open and accessible. As an American citizen who served the United States Army for 18 years, retiring as a captain military intelligence, and as the Florida State Representative, I know how important governmental credibility means to our system. And today, this concept is in dire need of attention. The bill will aid in this process. On my weekly radio show, here broadcast in Central Florida, which I've done, it's called I Need to Know. I've done it for over 20 years. The topic of governance of Puerto Rico is a topic of discussion every show, and it is always a hot debate. And this will continue until the island and the United States Congress finally determine Puerto Rico's ultimate fate. However, at the root cause of the controversy is trust in the decisions made by their leaders. Nothing is more sacred. Nothing is more important They're maintaining that trust between the citizen and its government. And this bill works toward that. We have had lots of controversies on my radio show. I've heard people about fees being paid to persons working with Promisa, huge fees. Meanwhile, as our previous speaker has spoken, the Puerto Rican workers are losing pension plans, the pension funding, the pensions are being cut, their future is being significantly affected. This cannot go on. So I urge Congress to pass this bill to ensure transparency and retain trust for the people. Thank you very much.
Thank you, sir. Now we'll go to our questions, and I'll start out with, and all three of you can answer this, whoever feels comfortable. The disclosure requirements of Rule 2014 of the Federal Rules of Bankruptcy Procedure are tied to hiring rather than paying already hired professionals. These requirements don't apply to Promisa because Congress has not wanted bankruptcy courts telling sovereign states, and by extension Puerto Rico, who they can or can't hire. Bankruptcy courts do, however, have authority to police the payment of professionals in municipal bankruptcies, and the Supreme Court has repeatedly said that the requirement that compensation paid to professionals in municipal bankruptcies must be reasonable, carries with it the power and duty to make sure that professionals are not only compensated for loyal and disinterested services, untainted by conflicts of interest. So the question would be, with the same requirement in Promisa that compensation must be reasonable, coupled with the bankruptcy court's broad, equitable power to issue necessary orders under the code, bankruptcy code, already provide Judge Swain the power she needs to order any additional disclosure she thinks is appropriate to police conflicts of interest? Whoever.
May I respond?
Judge Gonzalez.
Thank you, Mr. Chairman. I think in terms of could Judge Swain do it? Yes, I think she has the authority to do it. I think the problem would be if you don't apply 2014 through this bill, it wouldn't be as easy to be interpreted. There's case law that has developed under 2014. There's a great deal of guidance as to how it plays out. Judge Swain has not done it to date. So I think it would be easier if it were incorporated into the traditional disclosure requirements under 2014, such that the parties would know how to react to it, how to ask the court for variances within that structure. And so in that regard, I think it would be helpful. Second, although she could do it, what we currently have as a conflicts process, it does exist. I won't take the time to go through it in detail, but its depository is not the court. It's our website. Certain things are there. Certain things are confidential. So if the depository for this information, as it would be under 2014, was made the court, it would be easier to work with that material.
Anyone else? Ms. Lubin? Yes, sir.
I think I agree with everything that Judge Gonzalez has said. I would also add that I think there's something to be said for Congress to expressly state that this is our policy. Yes, Judge Swain could probably end up in a similar location, you know, using her equitable powers, but I think there's a lot to be said for Congress weighing in and saying, this is the legislative policy. We want a transparent process in the Puerto Rican bankruptcy.
Yes, sir. Mr. Suarez.
I would like to add that the Congress has already taken the hit for creating Promisa and creating that controversy that Puerto Rico is not longer a sovereign. But now Promisa will take the hit for not being transparent. So it is important to disclose, and since we've got the responsibility Congress does, you might as well now go full length and say you must require full disclosure so you don't get the black eye associated with what you've already done.
Well, let me ask this. Does the Oversight Board in the Commonwealth of Puerto Rico already have and already require conflict disclosures before they hire professionals? Are they doing that? Judge Gonzalez?
I'm sorry. Yes, the process that we have in place, and it has evolved over the years, when someone is hired or when their contract is renewed, there's a questionnaire that must be filled out. That questionnaire generally centers around conflicts-type questions Responses are then sent to the board. Explanations, if necessary, are sent to the board. And a declaration is then prepared, attached to the contract, and then that contract is on file at at our website. However, there are 2 points I'd like to raise. First, to the extent a party has deemed some information to remain confidential and only shared to the board, the contract that would be on file with the declaration would not have that information. And in the second point, in terms of that, there are 2 professionals who have had evergreen situations without their contract doesn't come up for renewal, so they wouldn't be subject to the evolving disclosure process, but in the context of their fee applications, their contracts have been attached. So again, it just comes back to what I said, the 2014 would provide this central location where it is not the easiest database to navigate to find where all this information is currently.
I'm going to take a little bit of a liberty here and ask one more since our time, but I think we're going to be in good shape today. If Congress enacts the bill, should it give Judge Swain the discretion to consider if applying Rule 2014 to the pending Promisa case would be just and practical and allow her to tailor its application if it is infeasible or would work an injustice?
I don't think it would work an injustice. Well, I don't think it would work an injustice. I think it is not retroactive to the fees that have already been subject to an order of approval. Its relation back, as I explained earlier, may be difficult to deal with, but I don't think it would be unfair. She certainly could do it, and I think the implementation of the standard approach to 2014 in large cases, she should have the discretion to employ to ensure that it would be an effective process.
Thank you. Senator Barrasso.
Well, thank you very much, Mr. Chairman. I have a couple of questions for Mr. Suarez and then one question for all the witnesses. Mr. Suarez, this past Sunday, about 70 years ago in 1952, Puerto Rico became a self-governing Commonwealth of the United States. Since that time, the island has faced financial difficulties that has required the Congress to provide oversight that resulted in the Promisa law. Do the House and Senate Pravda bills we are discussing here today, do they address a need that the Promisa law does not?
Could you please repeat that question for me? I'm sorry.
Well, the question is, do the House and Senate Pravda bills that we are discussing here today, do they address a need that the Promisa law does not address?
Yes, I think it does, and that specifically it closes that loophole, as you've discussed, that it allows for some transparency on these fees. This is a big issue in Puerto Rico. You're constantly hearing about teachers being cut and sanitation guys losing their pensions, police officers losing their pension, whereas huge fees are being paid out to the persons, and people do not understand. I think this bill does provide a close to that loophole. I think we should be giving the judge's discretion, because then it takes it out of the political realm. People will perceive it as a judicial decision, and it lessens the political impact, and thus I think the transparency of it and acceptability of the bill.
Well, thank you. And then a follow-up on that, Mr. Suarez, relating a conflict of interest. So with regard to Puerto Rico's Financial Oversight Board, how important do you think it is that there are disclosure rules in place to ensure that there's not even an appearance of a conflict of interest in the advisors that the board hires?
I think we've already spoken about this in some detail. It is paramount importance. There is absolutely nothing more important than the trust that the society has in its governance. Puerto Rico is suffering greatly and has suffered greatly from both political parties, and the people are really, really angry, and they're frustrated. So this bill, what it does, it gives some transparency to it. It exposes it will be on the island. It will be translated as an exposure of those people, the elites, for controlling the government, and thus puts a stop, at least the appearance of the stop, where now they have to go in front of a judge and they have to disclose those interests, so that it just feels better.
So if I could ask you one question, then I'm going to ask the other two witnesses to comment on it. And the question is this. Is there any reason why the bills that we're discussing here today would not improve transparency for the public and shouldn't be taken up by the committee and the full Senate? Any reason we shouldn't be doing this? Mr. Suarez?
Oh, no, absolutely not. I see no reason. And the question of whether the judge would be very costly. The cost of not having people believing in their government is 10 times more higher than the cost of whatever is incurred by requiring additional paperwork done in this case. So there is just no reason.
Great. Judge?
No, I know of none, Senator.
All right. And Mr. Lumen?
Yeah, I know of none. I make some very small technical changes in my written testimony, suggestions for
Sure.
changes, but definitely it should be passed.
Thank you, Mr. Chairman.
Thank you. Senator Rono.
Thank you, Mr. Chairman. Thank you for holding this hearing. I am a co-sponsor of this bill, and I think it's a very common sense approach to the concerns that the people of Puerto Rico have, that as they are footing the bill for all of these advisors and consultants involved in these bankruptcy proceedings, and at the same time as their pensions are being cut and teachers are being laid off, et cetera, I think it makes perfect sense that they should know whether there's any conflict involved in the people who are involved in these proceedings. So I'm grateful that you're having this hearing so that we can address some of the concerns that have been expressed, although I have to say that I'm not quite understanding why these concerns should delay the passage of this measure. I'm glad that Representative Velasquez has worked so hard on helping the people of Puerto Rico, along with, of course, our colleague Senator Menendez, that this bill is now before us. I have to say that both Senator Menendez and Mr. Suarez have pointed out how important this bill is to the people of Puerto Rico. As I said, they are the ones footing the bill. They should know if the people they are being asked to foot the bill for should understand whether there are any conflicts of interest. So I do have a few questions. For Professor Lubin, Judge Gonzalez, in his statement, said that technical application of the term creditor would render compliance with the statute practically impossible and extraordinarily costly, and he suggests changing the bill from creditor to interested party, and I'd like to know if you share this concern that Judge Gonzalez has raised regarding the bill. Professor Lubin?
It's not an unfair concern, but I also don't think that the bill necessarily needs to be amended to address it. I think, as Judge Gonzalez himself well knows, bankruptcy judges, and I would include Judge Swain in this, have a lot of experience of managing these rules in big Chapter 11 cases and figuring out how to make them work in a practical sense. So in other words, if you're overly literalistic about creditor, yes, it's very broad, but I think Judge Swain has the inherent authority to set up some ground rules to make this work in a practical sense.
And again, for you, Professor, I believe you noted that Chapter 9 should be revisited. And so this is in context of one of the arguments we've heard against this bill or concern is that the Puerto Rican bankruptcy should be treated more like a municipal bankruptcy under Chapter 9, where a disclosure of this type is not required. And so my reaction is, why shouldn't we require this kind of disclosure? And as you noted, we should probably take a look at Chapter 9 instead. So could you talk a little bit more about why maybe we should revisit the provisions that stop this kind of disclosures under Chapter 9?
Well, again, as I said in my opening remarks, I think in some ways the fact that we don't require the disclosures in Chapter 9 is a reflection of a 1930s view of what the Supreme Court would allow with regard to municipal bankruptcy and the 10th Amendment. So there's sort of two responses. Number one, the view of the 10th Amendment has changed since the 1930s, and that's a reason why Chapter 9 itself should probably be updated. And then, without getting too far into contentious issues, I think we also have to admit that Puerto Rico is not quite in the same position as a state. The existence of Promisa itself, right, and the Oversight Board itself suggests it's not quite like a state. And so the analogy to Chapter 9 in any event in this particular case is not particularly apt, I think.
I agree with you. It took a lot for us to acknowledge the situation that Puerto Rico was in and that it could not get into bankruptcy proceedings, so now that it can. So one of the other, if you don't mind, Mr. Chairman,
Please.
I just have one more
No
question.
problem.
There was a concern raised about the potential, about the jurisdiction provision of the bill, and Judge Gonzalez voiced concern that the provision may be read to allow a party to bring an action in a court other than the District of Puerto Rico. And doesn't Promisa already require that all cases be brought in the District of Puerto Rico, Professor Lubin? If that's the case, how would cases brought under PRADA wind up anywhere else?
Yes, Section 306 of Promesa already has a jurisdiction provision. So I get what Judge Gonzalez is saying, that the separate jurisdiction provision in PRADA is perhaps a little bit redundant. But I don't see that it does any harm for the reason he actually said in his oral testimony. At least as long as the Title III cases are pending, I would assume any other district court judge who got a disclosure case under PRADA would immediately transfer it to Judge Swain. So I don't see that as a really serious issue. Again, you could argue that maybe the jurisdiction clause in PRADA is a little bit redundant, but I don't see that as a fatal flaw.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator. Senator Marshall.
Yeah, thank you so much, Chairman. I just have one question for all the witnesses. Will the bills we're discussing today improve transparency for the public, and should they be passed by the Senate?
Give him up.
Yeah, whichever wants to go first. Yeah, go ahead.
We've already addressed this issue, and I think that it bears repeating. This is essential for the purposes of ensuring that Promesa is ultimately successful. Transparency is sumamente, all right? It is absolutely essential for have credibility on the island and actually outside of the island as well.
As I said in my opening remarks, I think transparency can promote legitimacy. So I do think this bill is very important.
Thank you. What's one more? Go ahead.
Yes, I would agree, but I'd ask your indulgence if I could say something about fees, because they've been raised in this context a number of times. The fees are enormous. There's no doubt that $1 billion of fees is an enormous amount of money. My own experience in cases in Enron in 2004 dollars, it was $760 million in fees, and ultimately $1 billion by the time the case was over, and it returned $22 billion to creditors. There are a number of items that impact fees. One is the rate, and with respect to us, we've gotten a discount across the board in the rates. The other is the complexity of the case. This is an extraordinarily complex case that requires the best of the best in terms of advisors. The next is the litigious nature. This case has been extraordinarily litigious over the last 4 years, and it's the length of time of the case. All of those add up to enormous fees. Another way to look at the fees, though, is in the context of what's accomplished. We have in the COFINA restructuring, there's $17 billion in future payments on the debt that were reduced as a result of that restructuring. In the settlements that have been reached to date in the Commonwealth case, and hopefully the plan will go effective, billions upon billions of dollars in debt has been reduced. So yes, it is an enormous amount of money. Yes, disclosure should be placed in the structure so people can know where there's money and who it's going to and whether there are conflicts or not. But by the same token, in terms of the value added from what has happened by the extraordinary work of these professionals, I think that those amounts paid were rightfully and justifiable under the circumstances.
So maybe I do have a follow-up question then.
You've got plenty of time.
So this legislation, started back in 2016, and forgive me if this has already been addressed. What is the financial health of Puerto Rico today compared to 2016? Which direction are we going so we're not just throwing good money after bad money?
I don't think I could give you a detailed answer to that. I believe we're on the road to getting the debt restructured. That should stabilize many aspects of the economy and ultimately return Puerto Rico to the public debt short and long term as one of the stated goals in the statute. I think there is a great deal more disclosure, I think, in dealing with the finances of the government that has been achieved over these last years. And I think it's moving in the right direction in that regard. And there's more certainty as to what's going to happen. But beyond that, I think I'd have to defer to some of the financial advisors to give you a more complete answer.
Thank you. Do the other witnesses have any comments? I know it's not your specialty, but, okay. Thank you so much, Chairman, and I yield back.
Yes, Senator Cortez Masto.
Thank you, Mr. Chairman and ranking members, for this important conversation. Listen, there's so much, and I thank you for the panels of work that needs to be done in Puerto Rico and for the people there and looking out for the best interests of the people of Puerto Rico. And so, Judge, let me start with you because I really appreciate the experience and expertise that you bring to this hearing with your focus on bankruptcy law. Can you do me a favor? Can you elaborate on how Puerto Rico's bankruptcy process differs from the typical process for states in U.S. courts?
Yes, I think one main difference is that the board represents the debtor in the Title III case. I'll identify the Commonwealth, which is the Title III case. However, the governor, legislative bodies are still functioning. Now, if you compare that to a Title IX case, so you really have two parties there, which adds to the expense in terms of professionals because you have the board having one set of professionals and the government having another. In a Chapter 9 case where a state authorizes a municipality to go into bankruptcy, most of the states, to my knowledge, put in, for example, in Detroit, an emergency manager will put in. That emergency manager literally takes over the control of the city for these purposes. And that would differ radically with how Puerto Rico, the compromise with Puerto Rico remaining, continue its sovereign aspects of its government, and at the same time compromising some oversight in the bill was given to the Oversight Board. It's more complex, I think, than the typical Chapter 9 case in which a municipality goes into insolvency and is controlled by either a board or executive management, or someone is put in control of that has virtually total control over both the administration of the government as well as the insolvency case itself.
And then for that reason, and you just touched on it, Puerto Rico has a role to still provide services for its citizens, and it still has to carry out the functions of a government as it's going through this bankruptcy, correct?
Definitely, yes. And
Go ahead.
our role is that of oversight, but we don't run the government. We look at it from a fiscal standpoint and try to put guardrails on in that process. But no, we don't run the government.
And then what role, because there's a lot of talk about the hiring of professionals, the fees that are charged to professionals. What role does the court have in determining the reasonableness of those fees?
The court? Is that, I'm sorry.
The bankruptcy court.
Well, the court, the district court that's presiding over the case has complete discretion in terms of the reviewing, having the fees reviewed and awarding what it believes is a reasonable amount of consideration under the circumstances. There is a fee examiner in place that reviews the fees and reports to the court his view on the reasonableness of the fees that have been incurred. The court will hold a hearing and hear objections if such were filed, and then make a determination of what she believes is reasonable under the circumstances, which is a mirror of what happens under the bankruptcy code. In the bankruptcy code, it's section 330 and 331. Under Promisa, it's section 316 and 317. Control the hearing and the awarding of fees.
Thank you. Thank you to the panelists. Chairman, I yield the remainder of my time.
Thank you, Senator. I'll have one final question, and this could be to all three also. As I understand Rule 2014, professionals are required to disclose all connections with the debtor, creditors, and other parties in interest, as well as their attorneys and accountants in a bankruptcy case. Although not defined in the rule in the bankruptcy code, the courts have given the term connections a broad meaning, encompassing more than conflicting interest. As you noted in your statement, Judge Gonzalez, bankruptcy judges have found it necessary to focus on connections with material interested parties, which may be defined by a threshold dollar amount in large, complex bankruptcies. My question is it practicable to require all of the professionals retained by the Oversight Board, the government of Puerto Rico, and the creditors' committees to disclose their connections with all 165,000 creditors in these cases? Or would it be more feasible to focus on a material interested parties list?
In response to that, I agree with Professor Lubin that when I raised the issue, my concern was that the judge would, depending on how the bill was written ultimately, there would be an argument that that discretion, the normal discretion that would come under 2014 wouldn't exist. To the extent the judges has a discretion under 2014 that would normally play out in a bankruptcy case, the judge would address that issue. In fact, ironically, and it's just as a technical point, 2014 rule already applies in the Title III cases in the context of the creditors committee, because under section 1103, which deals with the creditors committee retaining professionals, it also sweeps in 2014, and 1103 is part of Promisa. So as a practical matter, I believe the creditors committee's professionals are already complying with 2014, and they would be operating under a material interested party list, but they would already be utilizing it. And if this bill is enacted, I would expect that that would be the similar structure that would go forward with respect to this.
Professor Lubin?
I agree with what Judge Gonzalez has said. As I indicated earlier, I think because the bill expressly references 2014, the court would inherently have the same discretion to make the system work. And so you wouldn't have to necessarily include every creditor who's owed $5, for example, on the conflicts list. It could be limited to some sort of material dollar amount. And that makes it workable. That already happens in Chapter 11 cases, and I'm fairly confident that Judge Swing would do something similar in this case, based on the language that we have in the pending bill.
Thank you. Mr. Suarez?
I agree with Professor Lubin that we should have it a disclosure of a certain amount so it doesn't get so tedious of all those hundreds of thousands of creditors. My concern, Senator, is that you know, when what Judge Gonzalez correctly says is value added, there's the lawyers have done a good job, they deserve is what is reasonable. Well, in the law, $500 an hour for lawyers could be considered reasonable. A $1 million, $2 million, multi-million dollar fee, that's reasonable. But in the street, and I have two family members who are pensioners in Puerto Rico. One's a teacher, one's a police officer. And when your teacher gets a $1,500 a month pension, and she has no Social Security because of the way Puerto Rico operated, right? And then they take 20% of her salary away. This is huge for them. So the perception is very, very important. And I think that the more we can, still within reason so we don't create a bureaucracy unto itself that then it becomes inapplicable. By putting a certain number, a reasonable number, saying, okay, you have, you know, a conflict of interest, it's more than $20,000, $30,000, $40,000, something like that, then that could do it. But it's certainly important that these conflicts be reported as fully as practical.
Thank you. Senator Rono, do you have any more questions? Senator Cortez Masto, you don't? I'm sorry. Okay. I want to thank you to all of our witnesses for making this effort and being so helpful to us in decisions we have to make. Members will have until close of business tomorrow to submit additional questions for the record, and the committee stands adjourned.
Thank you.
Thank you, sir.